That is our presentation, but we've left time. I think we've got 7 minutes for questions. That's what we were shooting for, and we are open to any and all questions on the topics, because I know we went through a lot of slides in a hurry. What have you all? Yes, sir.
Is there a time limit by which you can discovery is restricted to? Like if you're in business for 18 years and you have a problem and there's an action being brought, is there a limit as to how far records can be reviewed?
Okay, the question is there a time limit? These parties have been in business together 18 or 20 years. How far can you go back? Great question. We have a case going on right now. It's public record, but I won't mention the names. But it's a case between two brothers who have a real estate empire. And our side, as the plaintiff, wants to go back more than 10 years. The statute of limitations on a claim for breach of fiduciary duty is 4 years. However, there are exceptions if there's been fraudulent concealment. If there's evidence that someone concealed from you the fraud, then you can go back. So the short answer to your question is, normally you can't go back 10 or 15 years, but we have emails from the brother saying everything's fine. I mean, we have emails suggesting that there was concealment during the period of time, which would enable us to go back well before the statute of limitations. And there's a provision or a doctrine in Texas law, and it's common law throughout 50 states, called the tolling rule. And the statute of limitations is tolled during a period of time where there is concealment, fraud. So as long as there's evidence of concealment, then you have a basis on which to go back longer ago in time. But if it's a simple breach of contract, no. There's no tolling that applies to contract. It's only to claims like breach of fiduciary duty or fraud. So if you're pleading a fraud claim or a breach of fiduciary duty claim and can show concealment and the ball was being hid, then yes, you can go back farther in time. Yes?
Do you have a number that's being bought out over time, 2-3 years?
Right.
Do you want to have a non-solicitation or non-compete during that time period?
A great question. So the question is, let's assume that you've got an owner and you're buying them out over time. Do you have the owner who's being bought out agree to a non-solicitation, non-compete? I've got one of those going on right now. And the answer is it's negotiable. The more you pay, the more likely you'll get them to agree to a non-compete. If you're paying them out over time and very little, a much tougher situation. Let me mention something, because I didn't, as we were going through this, on the buyout terms, sort of, it sounds like I'm being self-laudatory, but we were struggling to find something, because this was a tens of millions of dollars buyout, and our company's doing really well, but it didn't have tens of millions of dollars to pay. So I'm struggling to find out, how can I collateralize the buyout? And what I came up with, which ultimately got it done, I was trying to be as creative as I could, was, well, the company is generating a significant amount of revenue. That's why the value is so high of the minority owner we're buying out. We agreed to take a certain percentage of the monthly revenue and put it into escrow. Now, it doesn't mean he's collateralized right from day one, but we were writing a multi-million-dollar check to start the buyout process. And then he has that account, and we gave him online. He can see the money's going in. We do have to give him financial statements, but throughout the period of time, it's a 3-year buyout, he's seeing the amount of this collateral go up. So that's one way that we got the buyout achieved, was paying him the amount of money, and then creating this new account for him that if we default, he goes and gets it, and then we can use that account to make the very last payment. By the end of the 3 years, I think there's going to be over $7 million in that account, and that'll be then the last payment that we pay to him. So that's one way, when you don't have liquidity, to sort of get around on a buyout. But it's as creative as you can come up with to figure out ways, because many times when you do have a buyout, there's not the liquidity, and Jason mentioned you can go take on debt, but companies are reluctant to take on debt to buy out a minority owner. So this was one way we came up with that the minority owner was satisfied, because he could monitor that the payments were going in. Yes?
Yeah, because the owner dies without a will, how does that complicate?
The question is, if you have a majority or a minority or both, if you have a majority or minority owner and there's no will and they die, how does it complicate things? A lot. What you end up with, the will's going to be, subject to an executor, and you're going to have issues like that, and the executor is going to come in. Hopefully, whoever is monitoring the will has a business orientation, and you treat that person the same way that you would the original owner. But I will say this: if there's no buyout right, if there's no redemption right, the fact that there's a will doesn't give the executor or the administrator any greater right to come in and demand a buyout. If there's no redemption provision and no exit strategy, they're still stuck holding an illiquid interest out there. I've got one in Amarillo going on right now that's a business divorce where you've got mother at odds with the 2 kids in a series of family businesses. And the problem we have is, in that case, is that mom controls the businesses, but she controls it because she owns a big chunk individually, and then the other chunk is in trust. And she's the primary beneficiary and the trustee. The contingent beneficiaries are the adult kids. They view themselves as the owners because as soon as mom dies, they get it. But mom's not viewing it that way, and mom wants a business divorce, and the kid's attitude is, why would I pay you money for assets held in trust that's ultimately going to be mine? That's a really difficult, thorny issue. I don't have that one. I'm not creative enough yet to have that one worked out. But those are the kind of issues that you're dealing with because they created it through the death of dad. He died and put it in trust so his wife could have it until she dies and then the kids get it. And there's a big problem because there's a line of credit out there that's very large and she's personally guaranteeing the line of credit while the kids are running the business. So it's a very thorny issue when people die and they don't leave a clear exit strategy as to who's really in control. Yes, sir.
Usually one of the issues can be that any of the affected parties, when the ugly situations hit, don't have the financials to, sit down and deal with all this. So is there a mechanism where you can actually install, as part of the initial contract or agreement, a fund specially to pay for all the legal and technical fees that will happen or that will be needed in case that, a undesired outcome knocks on your door?
Yeah, I think the question is in advanced planning for this, how do you cover some of the costs associated with that? And I think from a cash management perspective, it's going to be difficult to allocate money out of retained earnings for that, but there's no reason from a contract perspective that you can't assign who's going to bear the cost of some of the cleanup in your operating agreement, in which you say, okay, if I have to hire a lawyer because you won't honor my redemption right, then I have a right to recover my attorney's fees. Or if we hire a valuation person and it's going to be $15,000, the company agrees to pay the valuation, or the owners agree to split the cost of the valuation. So you can allocate some of these costs. Having audited financials and having outside accountants who are regularly preparing audited financials and auditing the business or doing some kind also provides an extra check, and so that's a front-end expense that often doesn't make sense when the company is really small, but once it gets to a certain size, that can help provide some clarity that the numbers are real.
One other tool that we use is in that whole original buy-sell with clients, it's asking them to put life insurance in place that builds cash surrender value. And then actually saying that though that cash surrender dollars can be used for those kinds of costs, it can be withdrawn and pulled out to do that and borrowed against. And so it's a way to not only fund the cost, but also in the unexpected death of a partner, have a way to pay their spouse or someone off so that with an agreed upon methodology and stuff, so that it allows everybody to work through this in an orderly process.
I mean, two quick points to your question. Number one is, to follow up to Jason's point, is smaller companies operate with less formality. That's not a problem, but they should have some financial reporting. And so getting some required regular financial reporting. We've been involved in situations where people haven't seen a balance sheet or a financial statement for years. And it's very hard to then go back and deal with that. So requiring regular financial reporting in the governing documents is a good way to avoid some of the expense that you're going to incur if you don't really have a sense of that. The other issue is this goes back to the corporate hygiene, is having regular meetings. Very often these smaller companies, we don't need meetings, we're a small business, we see each other around the water cooler. Again, requiring people to get together to talk about business issues, at least on an annual basis, is really helpful because that allows people to bring up issues and say, well, what about this corporate retreat center that I see on the balance sheet? What is that, right? I mean, and this is not something we're making up. It was $1.2 million. We represented a minority owner who only gets 7%, and he came in and just said he bought a ranch or a lake house for $1.2 million and called it a corporate retreat center, right? The problem is that it's at a 7% owner, That's $84,000, right, that he should have gotten as a distribution. So are you going to litigate over $84,000? But what you see in some majority owners have a very strong sense of entitlement. It's my company. I built it. I can pay for college tuition for my kids. I can put my wife on the payroll, even though she does, so I can get her insurance. There's a lot of that going on. And then the person leaves the business, and now all of a sudden it's not okay anymore. So corporate hygiene is good, and having those regular meetings would bring some of that to light, and maybe you'd avoid some of that.
Let's call it
Okay,
opinion so
thanks.
everybody can head out. These guys are going to stick around this morning and answer questions and stuff. We really, really appreciate everybody showing up, and we appreciate your time. Also, just a reminder, feel free to take the information and stuff with you. Fill out your evaluation forms and stuff this morning. Turn those in. They also have parking validation out there. If you've been here for a period of time, just talk to Andrea on the way out and she'll get you set up. Again, thank you so much. We really, really appreciate it. And we'll keep you notified of when we're going to start back up in September. Thank you.